The fifth area we'd like to talk about that we think non-insurance lawyers need to be aware of is, we call it cyber intellectual property claims, but the real title should be the broad scope of coverage afforded under some of these standard form policies that everybody buys. And here it's general liability insurance. So cyber claims are big. Unfortunately, they're bigger than most companies would want. There's a lot of them out there, and there's a lot of money being spent on cyber claims. Intellectual property claims. Intellectual property disputes are all over the place. There's many lawsuits being filed. They're being filed all over the country. One business claims the other business is infringing on their copyright. They claim one business is doing something they shouldn't do. It's classic business torts that you learn about in law school. Let me cover the cyber claims first, because I think that's the starkest example. The insurance companies are selling broad cyber coverage. They're not paying claims on that coverage. They're denying those claims. But they're selling a product and then they're yanking it back when a claim comes in and they're saying we're not going to pay for that. So corporations are caught in between. What do we do? What do we do? But silently behind the scenes, there's been a whole series of cases that have looked at cyber liability under these old policies, general liability policies, which have been around since the 50s, maybe the 40s. These are policies that cover bodily injury, property damage. They cover you if you break your leg on someone's property. They cover you if you accidentally start a fire and burn down someone's warehouse. Those are the classic things they cover. But they also cover something called advertising injury. And advertising injury is probably one of the most overlooked areas of coverage in insurance coverage law. Advertising injury can be exceedingly broad. In fact, there's been a series of cases, one after the other, that have held that cyber liability is covered under these old advertising injury provisions under general liability policies. So on the one hand, companies are spending piles of money on these newfangled products, and the insurance companies are turning a blind eye and denying coverage and not paying those claims. But on the other hand, policies they've had for years, they've bought every single year for tens if not hundreds of, well, depending on the company, they've bought since their history of being around. General liability policies cover such really simple stuff, and every company has it. So on the one hand, the stuff that's supposed to cover it isn't. On the other hand, the stuff that nobody thought covered it does. And it's under those advertising injury provisions. Just to give you some background information, let me cite a few cases here. So if you're inclined to do so, you can go back and check the cases and understand why these claims are covered as advertising injury, as the cyber claims. The first one is a Netscape Communications case, Ninth Circuit case. The second one would be a Fieldstone Mortgage Company case out of Maryland. And the third one would be a CMA Mortgage case out of Indiana. And these three cases are cyber liability types of cases where coverage was found. So citations will be up. Take a look at them if you have that kind of an issue. Now, the other issue that I think is important to understand is just how expensive these cyber liability cases can be. It was reported, I think, a year ago that the average cost was $3.5 million roughly. $3.5 million for a cyber liability attack. Just recently it was reported that the average cost of a cyber liability attack was $150 million. Obviously you can't compare these studies as apples to apples, probably apples and oranges a bit, but the bottom line is it's expensive and the costs are going up. So that's general liability coverage. I talked a tiny bit about cyber coverage, but I want to talk about the intellectual property piece because we've had intellectual property lawyers across the country come to us and say, you know what, in our book, that's the number one issue is intellectual property coverage because their clients are being sued right and left by other technology companies claiming that someone infringed on either their trade slogan, trade dress, copyright, whatever it may be, but someone infringed on their business model. So these claims are very common in corporate America, especially with the technology companies. So what we're finding is that those claims can be covered under general liability insurance policies, again, under the advertising injury provisions. So let me just give you one example. A major consumer electronics company, one that you'd be well aware of, our client, you probably have a number of their products in your home. They were sued by another entity, basically claiming another entity, which is a world-renowned name, sued by one Goliath, sued by another Goliath over intellectual property issues. They basically claimed you shouldn't have put one company says you shouldn't have put our stuff in your product, it's ours, you shouldn't have taken it, you shouldn't be there, and they want all kinds of damages, major damages. Now, I don't think the suit had that much merit, the underlying suit, but it was costing a pile of money, and sometimes corporations fight each other that way, and that's just unfortunate, but it happens. So our client said, what can you do for us? And we said, let's take a look at it. Looked at every single policy under the sun. Guess where the answer was? General liability policy, advertising injury. So we went back to the insurers and we talked to them about, what can you do here? They said, you can't do anything. We've denied coverage. We're sorry, it's not covered. We said, we think you got it wrong. We wrote them a couple letters. They wrote us a couple letters. At the end of the day, we settled for 100 cents on the dollar for defense costs and 100 cents on the dollar for settlement. So our client got off spending zero, which was a great result.